to Milad because tomorrow last date Milad. Jain.
All right, let's see. Fresh filing, Mr.
No, Milad, earlier division bench of Kisanapur court.
Then, Mr. You, please, what were you doing? You knew, when did you know that last date is tomorrow?
Yes, 31/8/2023. I
You
know
knew.
Milad. I downloaded on 1/9/2023. So that Milad.
But we will take it up tomorrow. We will permit you to join. There is nothing. If because Mr. Rao has to be put to.
Yes, sir.
He must not have brought the file also. How can we take up today?
Already I have
Only those matters today will be taken up of which Mr. Rao has noticed.
I have already informed him.
All. Yes. Huh? Tomorrow?
Tomorrow.
Tomorrow. Yes.
Malad.
In fact, all madam.
For tomorrow, Malad, medical admission matters, Your Lordship. Seeking for tomorrow.
Get ready. The question of delay in approaching the court.
Yes.
Fine. We are putting everybody to notice, right? You just come like this, and at times you don't know what is the prayer also. Please.
Tomorrow.
Lordship say in my matter, Milad, covered judgment of Honorable Supreme Court.
Sorry, what? This is PG is done, right? Tomorrow. PG, your PG matter is tomorrow, right? Then what is somebody some other mention memo? Arey, Mr. Prabhakar, you made a request for PG. It is coming up tomorrow. Then what else? Covered by Supreme Court, which judgment?
WP number 944 of 2020.
Another mention.
Yes.
We will take it up a little later, Thursday. Thursday is a holiday.
But the last date of joining is only tomorrow. So that
We have granted tomorrow, no? So we have only one mention memo.
only one.
So coming up, we told you tomorrow. Yes. Yes. Yes.
Check.
Yes, senior counsel.
Pass on this, sir. Small synopsis and chronology, my lord.
No, nothing, no synopsis. It is admission. And you say that this WP is pending before single bench only.
It is not listed till now. I just pass on that.
No. WP 913, it's an interim order deferring the proceeding, obviously under a misconception of fact that WP 913 of 21 is pending before division bench, which is not so.
Not so, my lord.
So then you bring this fact to the notice of learned single judge. We will request him to pass appropriate orders.
I leave it
Let's
there because
yes.
only
This
thing, my
intra-court
lord,
appeal-
post along. I just pass on synopsis. That's 913, my lord, is yet to be posted before learned division bench as per the orders of the registry.
Division bench?
It has not yet been listed. It has been
No,
referred.
what is your point, mister?
My lord.
You have taken a point that 913 is in fact before single judge, which the single judge has
Not
not
yet been
taken note
listed.
of.
It's not yet been listed.
It
That's
is
the reason I just passed on the synopsis, my lord.
What synopsis, mister?
Why I asked for it is that the third page, my lord, chronology.
No. The only question is, mister, we are senior counsel, whether 913 is pending before division bench or single bench. From the memo of appeal, if you have seen, whosoever has settled, you have taken a ground that 913 is before single bench.
Lordship, may.
So we will,
I'll file appropriation.
yes, we will say so.
913 is before division.
This intra-court appeal has been,
913 is before, is a reference, Milad. There is a reference.
I stated so in my synopsis that 913 Honorable Learned Single Judge on earlier occasion synopsis dates were at third page. That it was referred.
but you said single bench.
Yes, sir, that's the reason, Your Lordship. You may see page 3 where chronology.
At least, mister, on facts, there should be no
but
variance from
that's true, but
when a senior counsel is appearing. That's what we
That's the
expect.
reason it's chronology and faster.
Treated as.
Item 6, my lord.
Where
Record
is the
the,
order of reference, Mr. 913? Order of
I have not
reference.
the petition, but I could not get a copy.
Where is the order of
I'm
reference?
also not the.
We are not officials.
What basis you are saying that it has been referred to division bench?
That is mentioned in the order, and Your Lordship may see the synopsis point.
No. He is saying that it is pending before single bench. You are saying it is before division bench.
They are also
So if you are proceed, tell us. Then you said that it's a reference. So please produce a order sheet of WP 913 to show that it is pending before division bench.
6, Milad, Your Lordship may kindly see 6.
This intra-court appeal. Unfortunate, Mr. Simple question you are asking.
6 million, that is what?
Six is the order.
No, 6 in the synopsis that is furnished by them. It also shows
Mr. What did we ask you?
23/2013, there is a reference order. That is what is mentioned by them
When
also.
it's a reference, then Mr.
Yes,
Well, my
What
submission,
is wrong with the order?
no, it is
You
not.
file an application before single judge.
Appropriate clarification, I'll seek on that.
This mark the presence with consent of the parties, matter is heard, condone delay allowed. Then with consent of the parties, matter is heard finally. This intra-court appeal has been filed against an order dated 14/7/2023 passed by learned single judge, by which learned single judge has deferred the proceeding in the writ petition till decision of WP number 913/2021. Learned, the senior counsel for the appellant submits that by an order dated 20th March 2023, learned single judge 20th March 2023 passed in WP number 913/2021, the learned single judge has referred the matter for to the division bench. However, till today, the matter has not been listed. Full stop. He submits that he be granted, learned senior counsel for the appellant submit that the appellant be granted to submit an appropriate application before the learned single judge. Full stop. In view of aforesaid submission, the appeal is disposed of with the liberty to the appellant to move an appropriate application before the learned single judge.
Achha.
Yes, next.
May I please alert? Well, a petitioner is the appellant. The petitioner is the appellant before the lordship.
We know it.
Yes.
uh,
The order passed on 16/6/2023 has been vacated by an order dated 8/8/2000.
who appears?
I'm appearing behalf of the 1 and 1 to 3, my lords, respondent corporation.
My lord, I am appearing for respondent number 4. my lord.
What happens if I stay is vacated? His petition right, he should live without electricity, right?
My lord,
Because he is not the owner.
my lord, may I submit this?
This is not the this thing, Mr. Right to electricity is one of the basic facets and forms integral part of Article 21.
My lord,
This you may be the owner. That fight it out with him in civil suit.
Yes.
may two submissions,
Yes,
my lord, then I leave
please.
it to your lordship.
Please.
We are brothers, my lord, and we
very good.
are partition.
Ah.
But, he being elder, my lord, he occupied my property. My lord, when there is a confusion, I approached this court, my lord, and got it surveyed. My lord, at the time of taking,
We are assuming for a moment that he is in rank trespasser. You are the encroacher. You are the owner.
no, my lord,
That doesn't affect his right to seek electricity.
Not,
You can evict him in accordance with law.
my lord, that doesn't stop there. My lord, he digs a borewell, he goes to electricity department, he gives an undertaking saying that this
Ye-
bore-
You are the owner, right?
yes,
He is in unauthorized possession.
yes,
Can you throw him out with the help of police authorities? No.
I am not throwing out.
So then take recourse to law. So long as he is in possession, in our opinion, he has a right to seek electricity. Seeking an electricity connection does not create any title in favor of anybody. We will clarify this.
My lord, I'll accept that, my lord. He gives an undertaking saying that this particular borewell,
He has given, we have seen
my
that.
lord, something obtained under misrepresentation and
If
suppression.
there is any objection, the authority can cancel. This is the undertaking furnished by him.
My lord, he specifically says this particular borewell is in survey number so and so. If any objection is there, I will be liable and service connection may be disconnected. This is undertaking on the basis of that undertaking.
He had applied for survey number 492/2 and connection has been granted 492/2 only.
Yes, my lord, in the affidavit, he says it is in 491/1. In the suit, he says it is in 491/1. My lord, a person.
Yes.
My lord,
You also know the legal position, Mr. You
Yes,
want to
Lord.
argue. We
my lord,
will
I am not arguing for the purpose of argument. I am only placing this before your lordship. Sir,
undertaking.
my lord,
We have understood he is bound by his undertaking. Therefore, no electricity connection can be provided to him.
My lord, a person obtaining something under suppression and misrepresentation, my lord, can he be allowed to do that? Only my submission, my lord, beyond that, my lord, I
Not the presence. With consent of the parties, the matter is heard. Finally, this intra-court appeal has been granted, has been filed against an order dated 8/8/2023 passed by learned single judge by which stay granted in favor of the appellant on 16/6/2023 has been vacated. Paragraph. Facts giving rise to filing of this appeal briefly stated are that the appellant stroke petitioner filed a writ petition seeking a direction to respondents 1 to 3 and respondent number 5 in the writ petition not to disconnect electricity supply to the petitioner service connection. Full stop. The learned single judge continuation. The learned single judge by allowed to he cannot. Please tell us what is the law.
My lordship's petitioner is my lordship's petitioner is a student, my lordship.
The student can do anything, right?
My lordship's
And you can seek admission in the month of December also. Why have you come? You have come a little early.
my lordship's may consider
No consider. We are passing an order. It's all. This can't be done. Yes.
even on merits also is not entitled.
See, you should see. Action table is published. In 2 months. There is no representation. We have taken a similar view. I was part of the bench which had passed an order in Karnataka. I am bound by my own view. We are referring to it also. And apart from that, Supreme Court decision also. Yes. Yes, madam. Petitioner is an petitioner with consent of the parties heard on the question of admission. Mr. Rao. In this writ petition, Mr. Rao for respondent number 2 and 2 and 3. In this writ petition, comma, the petitioner inter alia has prayed for the following relief. Quote. Paragraph. The petitioner had appeared in the NEET undergraduate examination which was held on 7th of May 2023. The petitioner was declared successful in the aforesaid examination and had examination full stop. The petitioner was treated as full stop from the averment made in para 5 of the writ petition. It is evident by the petitioner from the averment made in para 5 of the petition. It is evident that petitioner was declared as non-local candidate. Paragraph 5 of the petition is reproduced below, extracted below for the facility of reference. Quote. Para 5, you first write, delete, madam. What is the sentence? Delete. Para 5 of the writ petition reads as under. Quote. Thus, line below, thus it is evident that the petitioner was declared a non-local candidate on 2/8/2023. Full stop. Then when that petition was filed, will you get the date batch 33B? Right? The students, the students who are similarly situated like that of the petitioner filed. Zero. Full stop. and UP Power Corporation versus Ram Gopal 2021 bracket close 13 SCC 225 paragraph. We are aware about the paragraph, delete. The normal rule is that when a particular set of persons are given relief by the court, comma, all other identically situated persons need to be treated alike by extending that benefit, and not doing so would amount to violation of Article 14.
Mine also same notes.
That he is not entitled to similar relief. See, my problem is that so let's say you not of the that's why yes, yes, madam.
May please your lordship.
Yes.
Sir, I am
sir.
the petitioner. Your
What is the relief?
relief is the only to admit, declare me the local candidate in B category and C, lordship. Because I was already allowed in A category, that is convener category, sir. in writ petition 22038
No,
of
no.
2020.
So when were you declared non-local?
I was declared prior to my writ petition. Lordship in this
When
matter.
date, this all
Proceed.
missing in the rate petition, Mister. We go through the rate petition. That's why it is as vague as possible because it's inconvenient for you to plead the facts.
Yes, sir.
So you are missing. When did you, same principle applies. When were you declared as non-local candidate?
26 Lordship.
Huh?
26/8.
How?
Thereafter, I filed
No,
a
no, Mister.
22038.
Please appreciate if, I mean, the just petitioner in previous case was declared as non-local on 2nd August, right? The list was published. You are not an exception. You can't be treated as on 26/8. You must have been treated on 2nd August also. So no, fill an affidavit, Mister.
I was-
Along with the communication that you have been treated as non-local.
I was
Affidavit,
yes, yes, Lordship.
date you have not been given.
My
Yep.
my writ petition already allowed, and I was allowed as a local candidate. That is
Well, last night candidates, is, my lord, he wanted, my lord, the 85% reservation in B category. B category, there is no reservation. It's a management seats. Where candidates from all over India are eligible to compete B category seats. He wanted a special case, he should be treated as, my lord, a local candidate,
No, he is local candidate in this.
B category.
We can-
You are not.
They want exclusive order from the honorable court.
No. Which provision prohibits them from this thing? He has not challenged.
My lord, notification is there, my lord. 114, my lord, the rules, my lord.
So how contrary to rules a relief can be granted to you unless you challenge the validity, Mister?
Yes, Lordship.
Huh?
Entire
Which rule? Mr. Prabhakar, which rule? Mr. This, you have not challenged the rule. We will dismiss the petition saying that in view of this rule, you are not entitled to be treated as local candidate and you have not challenged the validity of the rule, therefore no relief.
That is the B category, Lordship. First of
Whatever
all,
category.
A category I was allowed. I was allowed as a local candidate for the admissions. And from
There is Mr. You have not anywhere said that B category, C category.
yes,
Read. This is what is most confusing here, that half a page prayer doesn't make sense because your this thing typist or the person who has typed this petition has typed the relief. You have not chosen to read it even today. Please read. What does it make sense? Read again. For our benefit, we have not read it.
yes, it is further pending disposal of.
No, it is there for
Yes, it is there.
page 10. In page 10.
Right, and honorable court may please to issue writ order direction, particularly in the nature of writ mandamus, to declare the action of the respondent number 2 not considered petitioner as a local candidate in Telangana state as per rank shown in the merit in the connection with the NEET admission petition as illegal or arbitrary. And so articles are put in 1921 in India, and consequently direct the respondent number 2 herein provide the admission to the petitioner by considering him a local candidate B and C categories.
So what is So what is B category?
B category is the management category. And C also category.
C is what?
C is the more cost than the B, sir.
Huh?
More cost than B. Category.
NRA category.
That is NRA and
NRA. So what is the requirement? Which rule, Mr. Prabhakar Rao?
Right now, I do not have lots, but kindly put it tomorrow. Right, yes.
plus.
No, if Mr. Please examine. You must have been, is it your case that under which rule you are entitled to be treated as local candidate?
In 3 lots.
Huh?
3. Roman 3.
Roman 3?
Yes.
Then the division bench decision is against you. We have already held that
Yes.
division bench decision is against you. We have held in that division bench decision that none of the cases of the petitioners fall under rule this thing. Until you challenge the validity of rule, you cannot get anything.
The last application, not the writ petition 22038.
Mr. Rich, we are not, please understand that we are not sitting here to convince you. Our job is to pass an order.
Yes.
Take a flight to Delhi. We will make the order available to you. Correct? We will
Tomorrow.
dismiss it, saying you are not telling us the rule. You have not told us when this thing you are treated as non-local candidate. This query we put, you did not answer. There's no material. You didn't say that I will place it on record that on 26/8 I was declared as non-legal. That is you are not doing except for making verbal submission. Secondly, which rule you are entitled, you don't know. Then thirdly, that rule you have not challenged. What can be done? Thank yourself for drafting such a petition.
Tomorrow,
And go to Delhi then. Let him go. What to do? This is all vague, not orally telling, not answering.
my submission, Lordship, I was already declared as a
That's
local
why
candidate.
when we say that we will dismiss, you immediately understand. So long as we are trying to tell you that please amend the petition, challenge the rule, you don't get it. The moment we say that we will dismiss, immediately you understand what is to be done.
Yes, Lordship. Tomorrow,
Not the presence.
I will amend the minutes. The permits that
We, from perusal of, we have heard learned counsel for on the question of admission, petition is admitted for hearing. Notice. Yes. Yes. Madam.
The petition is filed, agreed by.
No. Again, madam,
So maintain matter.
when,
Hello?
what was the last date of uploading?
Last date of 27/10/2022, madam.
First phase of,
Madam.
he did not exercise, my lord.
22, how can,
My lord,
he doesn't know.
she did
what-
not secure, secure the sponsor letter within the time, my lord, so that he.
Madam, we have gone through your petition. What was the last date for uploading the application? That is missing. And why you did not upload it, that is missing. Student MBBS is all right, but students have to participate in the examination as per the guidelines framed by the university, right?
Yes, my lord.
So you, all others uploaded, why you didn't upload? What is the date? When have you filed the petition? This is all vague, madam.
We have
The
uploaded,
petitioner should thank for engaging you. This is all. What is the last date of uploading?
my lord, petitioner has made a representation letter along with documents, my lord. Representation letter is in page number 22, my lord.
23, paragraph.
It's a covered order, my lord.
You don't, you haven't read, madam, the petition drafted by you.
My lord, kindly post it tomorrow, my lord.
Paragraph 5, you have said that it's 12/8. Brother is pointing out, you don't read your petition itself. What pity? What a pity.
I have read, my lord, 12/8/2023 last.
So why you did not upload?
My lord, we have given a representation letter, my lord, kindly.
No,
page
why you did not?
22, my lord.
Madam, what is the, why you did not upload till 12/8? Then comes the
We
representation.
did not get this
You
answer letter
withdraw.
at the time, my lord.
You
Respondent.
withdraw the petition approach, Mr. Rao, he will do whatever. We can't, see, if you depend on us, we will go by rules. The rules are binding on the court. This Mr. Rao can do anything. He can admit you even today also.
My lord,
Go there.
it's a covered order, my lord. Covered order is in page number 32, my lord.
No covered order, madam. Each case is different on the facts of the case.
Thank you, see, page number 33.
2 rounds of counseling are over, madam. In that case, the petitioner.
My lord, respondent number 2 is not allowing the petitioner to permit it
No.
web options.
No, madam, why have you come after, this order was passed on 22nd August 23? Why were you sleeping?
No, my lord, she did not
sleeping,
acquire this
right?
sponsor letter. Though she have made a representation, she did not acquire this sponsor letter, my lord.
Mr. Rao, should we pass a similar order like this or? Huh? All right, similar order. Page 32, certified copy today. No opinion on merits. It must be there. No merits. Like page 32, certified copy today. Yes. Madam, do better. Be more accurate in drafting things, right?
Yes, my lord.
My lord, it is same as that of item 4, lords.
4. All right.
It's not so, my lord. Here, my lord, the delay occurred, my lord. His grandfather was not well. And second thing, his son-in-law expired, my lord. And third, theft taken place in the locality of 4 to 5 hours.
Where? Which paragraph?
That's what I have left because that delay, lordship will proceed tomorrow. I will find
No,
a better affidavit.
No.
Because, my lord, I was under the view.
The theft doesn't mean that.
Theft is occurred, my lord, in the total locality of 4 to 5 houses. Breakover of flocks.
No. Mr. Theft happened. So this thing, you were declared as non-local candidate when?
After
Do it.
yes.
Identical order, Mr. We are sorry. We cannot take different view in different cases.
But what, that father was seriously ill, my lord. First thing. Second, son-in-law passed away, my lord.
When passed away?
There was a death, my lord. Then-
No, the petitioner's son-in-law passed away.
Petitioner, my lord,
Then-
father, my lord.
Petitioner had to apply. Petitioner had to apply. It has nothing to
No,
do
my lord,
with son-in-law.
The family, my lord, in the family, the son-in-law passed away. His
Son-in-law had not to apply for being treated as local candidate.
This, my lord, my grandfather was not well, my lord. After that,
Everybody's grandfather, all children's grandfather are not well because they are senior citizens, right?
Lordships,
It cannot be, mister.
lordships are aware in the joint family, my lord, generally
You file an affidavit, the order will be the same.
file tomorrow better affidavit, my lord.
Not tomorrow, day after. There's no urgency. When a query was put to learned counsel for the petitioner, no, delete. The petitioner is a candidate who has passed the NEET UG examination, which was held on 7/5/2023. The petitioner was treated as non-local candidate on 2/8/2023. However, by an order passed today in WP number 24378/2023, we have declined the benefit of the common order dated 29/8/2023 passed by this court in WP number 21268/2023 to a student. Full stop. Paragraph in the instant case also, the petitioner has filed this petition only on 1/9. When have you filed the petition?
Yes.
1/9/2023. 1/9/2023. Full stop. Thus, the petitioner is guilty of inaction for nearly period of 1 month. Full stop. At this stage, learned counsel for the petitioner prays for adjournment to enable him to explain the delay caused in filing the petition. List day after. List tomorrow. Tomorrow, Mr. You said tomorrow.
Milord, on 31/8, Milord, your lordships have passed, Milord, a proceeding sheet. What, Milord, enabling me to examine, Milord, whether this particular matter is covered by a judgment rendered by the
No, no,
Rajasthan
no.
High Court.
He was not clear. Mr.
Milord.
One thing, young person, times we want to tell everybody, not to you. All times you owe a duty to be fair to the court, right? All times.
Milord.
Because we respect you and we treat you as an officer of the court. You have a distinct status. You have been telling us covered. Now, this thing, the state of Telangana had issued the impugned notification on the basis of the
NCT notification, my lord, which has been quashed by the Honorable Supreme Court.
quashed by the Honorable Supreme Court. In this case, the examination was held on 12/6/2022. Already 12/6/2022 examination has already been held.
Yes,
And what has happened to that examination?
that the results have been declared.
Declared.
Yes,
So when have you filed the petition?
that this was filed on 6/6/2022.
6/6/22.
Yes,
And when the results have been declared?
that it's subsequent to this, my lord.
Where?
We filed it.
Date. Mister, you also don't know.
Milord, by that time, Milord, we have filed counter, but it is not.
Result has been declared when? You are the authority, you don't know the
Results, my lord, 27th June 2022, page 77.
what has happened to this thing. You have failed, right?
No, my lord, this is not a case where we have participated in this. We are the diploma holders. We are aggrieved by the state allowing the bachelors.
Mister, whatever is this process is over. Supposing this notification is quashed, who will be affected?
That the bachelor
No, we are asking you.
holders, my lord. Bachelor degree holders.
Where are
the diploma holders?
Where are they in the petition?
May I only, my lord?
No, where are they in the
No, my lord,
petition? Which respondent?
The bachelors, we don't know, my lord, who are bachelors, because, my lord, may I?
No means result has been declared, you should
Yes,
find out.
may I?
In
may
the
I-
absence of aggrieved persons, we cannot grant any relief.
May I only submit this, my lord? The rule has been challenged. Rule, my lord, may have to go because in light of the Honorable Supreme Court judgment, my lord, quashing the NCT, rule may have to go. My lord, so far as the notification is concerned, they may have to take steps, my lord. I would not press on that.
Interim relief, no interim relief can be granted
No,
to
my
you.
lord, it's
We
a-
will examine it the ledger.
Heard.
Petition heard on the question of admission.
Now, my lord, I'm sorry.
The petitioner have assailed the validity of the government order dated 23/3/2022 issued by Government of Telangana by which guidelines have been issued for conducting Telangana state teacher eligibility test under Right of Children to Free and Compulsory Education Act 2009. Paragraph. Admittedly in pursuance of the aforesaid notification dated 23/3/2022, the examinations have been held on 12/6/2022 and the result has been declared on 27/6/2022 already. Full stop. The selected candidates are not in full stop. The petitioners filed this writ petition challenging the validity of the rule on 6/6/2022. Full stop. Therefore, at this point of time, especially in the absence of selected candidates before us, no case for grant of interim relief is made out. Accordingly, same is rejected. Petition is admitted for hearing.
My lord, this is not a recruitment notification, my lord. This is a teacher eligibility test.
What interim relief you are seeking?
My lord, my respectful submission is
What interim relief you are
that
seeking?
main relief itself, my lord, is that.
All right.
My lord,
One minute. We will amend it. Correct.
I'm sorry.
Correct. We will amend ourselves. No problem.
I apologize.
Thank you for correction. Has been held, etc. Right? In the absence, delete. Delete absence. The petitioner, by way of an interim order, has sought stay of impugned
judgment.
We will
I
consider.
filed IA, my lord, to explain
Let-
the,
Let IA1 of 23 be listed for consideration in the first week of October 23.
I'm grateful.
Yes.
But these are respect of Ganesh person, Ganesh ID.
Hmm.
But I have made a counter affidavit on behalf of the THMC today, but what I was informed report, not earlier the last year, about 3 lakhs KIDs
Who is appearing for petitioner?
and I am appearing for petitioner. In my petition, counter is not. But Thursday, if your lordships have it, well, for the reason number 12, for the reason, my lord, till yesterday, my lord, they were busy in distributing the 2-bedroom houses, my lord, for 10,000 people. The GHMC staff.
Oh.
But
So when will you file counter, Mr.?
The
They have to be decided, you will agree.
but day after, no, I'm sorry, my lord, I'm sorry. I only request my lord, to have it day after tomorrow. my lord.
Day after. By that time, you will file counter.
One counter is filed, my lord, additional affidavit is required to bring it. to-
Yes, petitioner in this petitioner, you are an association, right?
Yes, correct.
Petition, which is an association of Ganesh idol artisans, seek a direction, challenge the inaction on of the respondents 1 to 5 in not considering the representation dated 18/6/2020, seeking permission to sell Ganesh idols made with plaster of Paris prior to 2019. The petitioners in addition seek a permission to sell the same during the ensuing Ganesh Chaturthi celebrations in the year 2020-23. Mr. Harendra Prasad, how many idols you have? You should tell us the number also. It's vague.
That is my writ petition, Your Lord.
Madam, you should disclose if
Yes.
you had constructed during COVID period.
Yes.
What are you doing? Number of idols apart from validity. This all covered. If you study, you will find the answer. What is it?
Milord, I am
File as
Yes.
number 10, Milord. I am appearing from video conference, Milord.
Yes.
Yes, Milord.
Yes, Mr. Prasad is seeking time till day after tomorrow, so we are adjourning the case. We are only telling petitioners council, it's all is decided, but they have not studied and they will only argue.
And Milord, the government is not deciding in this matter, Milord, in spite of the Supreme Court direction, Milord.
Yes. You will, day after tomorrow, please appear in person and tell us the guidelines. Mr. Harendra Prasad, learned senior counsel, whatever. It's attached to so and so. Place for short accommodation to enable him to file a counter.
I have filed a counter, additional affidavit.
Additional affidavit. List on. You find the answer, Mr. We already have the answer. Today also we can dictate the order. These people are not ready. They will.
I informed this court, my lord, that we had provided 3 lakh clear idols last year. I wanted to place the figure before my lord for this year to avoid
This is all
stumpy idols.
plaster of Paris, all for this thing, environmental pollution. This all
We
has
have
been
created 25 basis
List
points
on.
for it.
list on tomorrow. What?
Day after.
Tomorrow, Milord, because already the POP ideals are being.
No, Mr. We don't have any problem. The thing is, he is paying for day after is what, 6th?
Yes.
No, Mr. It can't be 6th.
So far as for Friday.
No, it can't be, Mr. 6th, we already have 102 cases. It can be either 5th or 8th, whatever choose.
8.
8th, Mr. 8th we will decide. 8th we will decide, Mr. We are ready today also. After final order in this case, also we are ready. 8th December. 8th, sorry, September.
I'm deeply obliged for my.
Item 11, 12.
Day after.
All right, same order. Where is that, madam? Next file.
Guidelines are under chart.
1 minute. We know that. See, Mr. You should better study. Have you studied it? It's issued by Central Pollution Control Board. It may have been examined somewhere. Challenging saying that it is violative of Article 1421 is fine, right? But you have to substantiate this. Anybody can say violative of Article 14, this thing, 19, 21. In this writ petition, next case, 12. Petitioner has assailed the validity of the revised guidelines issued by Central Pollution Control Board for immersion of idol, totally banning plaster of Paris idols. Full stop. Mr. Prasad, what do you want? Additional affidavit? Counter. Mr. Prasad, Harinder Prasad, what? Prays for short accommodation to enable him to file a counter in this writ petition. List on whatever, 8th of September 20.
I'm deeply obliged.
And no further time will be granted, my lord.
No further time we will be granted and we will decide it. You are for the petitioner.
No, I will
No,
repeat
he's a
petition.
third party. He's an intervener.
Intervener. So these people should be ready. We will decide it on 8th. Forget Mr. Prasad. Once indulgence has been shown to him, if he is not ready, you are on a question of law. Argue. How Article 14, 19, 21 substantiate your submissions. Legal issue. Yes.
But I am for the respondent.
Hold on the question of admission. Petition is admitted, record peruse petition is admitted for hearing, counter if any be filed within 6 weeks. Six weeks further time, you say, further time. Same order. Petition is admitted for hearing. Interim order granted on 3/8/23 shall continue. 6 weeks further time is granted to file counter. Counter 6 weeks time. Interim order is already there. Yes. 6 weeks we have granted. That's why senior counsel. No. There is already an interim order in your favor, right? So we have said interim order shall continue. Yes. Mr. Please appreciate that today have you seen the final hearing list? Which case is the oldest one? 98. We can't hear even if they file return tomorrow. We can't hear it day after. Right. There is an interim order. Nothing happens. Everything is subject to the result of the petition. Yes. Yes. So two questions, Mr. You are respondent, right?
Yes, ma'am.
Whether petitioner was heard, which provision empowers Lokayuk to stop construction? Act, Lokayuk Act.
There is no act.
Huh?
So in this case, my lordship, there is a conflict between it.
You don't have any power. Well, order. You have the power. You are municipal corporation, right? Who are you?
Lokayukta, my lordship.
Lokayuk. Then who appears for municipal corporation? Nobody. Then
Surendra Reddy is the municipal corporation.
not appearing.
I am appearing for respond number 2, my lord. In this case, my lordship.
No, corporation.
Corporation Surendra Reddy.
Huh?
Mr. Surendra Reddy.
Not appearing, right? Fine. Under which provision you have power to stop construction? And how it can be allowed to be fettered by a direction issued by somebody else who has no power? You have your independent power. You means Mr. Reddy.
Yes, my lord. Corporation. Warangal
Corporation. Yes. Mark the presence.
Both is fine.
You are a corporation, Mr. Reddy.
Very fine. Very fast.
So how Lokayuk has jurisdiction to stop construction? No, if he commits, he holds a public office and guilty of misuse, and then you approach against him to Lokayuk.
My lordship.
No, this order has to be quashed because it is from the dictates of somebody else who has no authority in law. You, Mister, you will be at liberty to approach this Greater Warangal Municipal Corporation, not Lokayukt.
Yes, I have already approached. I filed a representation. Last week, I did for this product.
In this writ petition, mark the presence with consent of the parties, same is heard finally. In this writ petition, comma, the petitioner inter alia has assailed the validity of the orders dated 28/12/2022 passed by Lokayukt State of Telangana and order dated 31/3/2023 passed by Greater Warangal Municipal Corporation, by which the appellant has been asked to stop further constructions until further orders of Lokayukt. Paragraph. Admittedly, the Lokayukt under the provisions of it is considered by admittedly under the provisions of Lokayukt Act, right? Which year? Lokayukt Act, which year? Find out, madam. They don't know. Lokayukt Act 1983, Lokayukt has no power to entertain a grievance with regard to construction, full stop. Therefore, full stop. The aforesaid legal position has not been contested by learned counsel, who appears for Lokayukt as well. Paragraph. Therefore, it is evident that the Lokayukt had no authority to issue the impugned order dated 28/12/2022, and consequently the Greater Warangal Municipal Corporation had no authority to issue the impugned communication dated 27/3/2023 based on the directions of the Lokayukt. Paragraph. For the aforementioned reasons,
The earlier order, last, give representation, I have given representation.
we have said that it shall be at liberty. It is not a petition filed by you for in his petition. We cannot grant relief to you by directing. Nothing.
May be fixed, let me worry.
It will be looked into by them. Same order.
Same
Same order.
28/12/2022
and this thing Lokayukt 28/12/2022 and Greater Warangal 31/3 allowed. Same order. Yes.
May I please?
Yes.
I beg to represent Sagarika.
Non-speaking. Mr. Rao. Yes, we know non-speaking order.
That's my kindly see, my lord. That's my kindly see the order passed by the University is page 15, lord.
Page
15, lord.
1. Hey, we thought that you will tell us that we will pass a fresh order.
I'll pass.
Right.
The same order I have to pass because the GO.
No. Speaking order. Grievance of senior counsel was confined to only non-speaking order. He will pass a fresh order.
I'll have to come back, my lords.
We don't know. So then we have to examine this then. Give them.
I have to,
See,
well, I'm saying.
we are telling 1st of September, we only recorded this contention.
I'm aware of
So therefore,
No, last time,
it has to be heard.
last
You are
time.
saying that you are right in saying that you will have to come back. But thing is that then in that case, he has to be granted the faculty to file counter.
Well, I'll tell you, Lords, what's happening. I'm just taking liberty, my lords, because I see a few more matters happening. Unfortunately, today, what's happening, my lords, while the citizens' grievance is being microscopically examined, state action is getting a lot of laxity. This is unfortunate. After all, it's too late in the day for me to come and tell your lordships. 226 is for supervision of state action. What's happened, my lords, for example, in this matter, when your lordships passed it,
No, you are talking about the orders passed by this court.
generally,
Yeah.
not your lordships. I'd be too
Because that is,
unwise to say that.
we can't do anything about it. You have the remedy under Article 136 if we pass that.
Unwise to say that. I'd be too unwise to say. All that I'm saying is this. Look,
Obviously, the only thing is what we are telling is last date of hearing in your presence, this order has been passed. That the only, this thing is a non-speaking order. Probably that's why, but you are saying that if it is quashed, then on this ground, you will have to come back again. You are justified in saying so. But only thing is, then we have to give them some breathing time to file counter. Because if we allow your writ petition today, the order won't stand because you will not be possible to, it will not be possible for you to defend.
36 is not any difficult.
No, defend it in saying that the court has not granted any opportunity to us to.
Only problem.
If you would have been for respondent, I think in Mr. Rao's position, you would have said that, sir, I need time to file counter.
I envy my lords, but
No.
only sensitivity I'd like to bring out.
My friend, Lords may kindly, I just, Lords may kindly say the similar cases are coming and coming. University addressed a letter to the government seeking exemption of the rule for giving a notification. There is a rule what press registration after the cutoff date. Rule 126, Lords may kindly say, page 126.
No, but you want to file counter or you want to, he is ready.
File my counter.
I will right away.
My friend also there is no need to make an argument. The university addressed letter to the government seeking permission for giving a notification, calling applications.
Who is appearing for government? Nobody.
I believe the respond number 1.
What have you? He has written something we don't know. So yes, Mr.
Lords, I think this is a very sensitive input.
Yeah.
We will now require a response from the government.
That's why we are granting them time.
Sleeping elephant that we
2 weeks time. Meanwhile, most probably notification will come. He may not apply. But even on the delay ground also it also be dismissed for the simple reason. But the notification for the student 3.8 ended with the 12.8.
No, they were in first round of litigation. They were here.
Yes, they were. In any event, they are now bound by your lordships earlier.
36, no. Page 36, earlier round of litigation, he was there. Then 19.8 an order was passed, then he has come again. He doesn't want to come again now.
But 2 weeks time, I'm granted, I file my counter.
Do we have that much of time in hand? We don't have
1 week. 1 week.
Mr. Heard, Mr. L. Ravichandar, learned senior counsel for the petitioner with so and so. Mr. This thing, you also don't want to respond.
I am respond number 1. I will also get in.
He submits that he doesn't want respondent number 1 accepts notice. Mr. Prabhakar Rao, 2 and 3, praise warrant is granted a week's time to enable him to file counter. List on. One week, next Monday.
Next.
12th September 2023.
Sorry, my lords, if I had taken too many liberties.
No, we thought that probably you are saying in the context of orders passed by this court.
No.
Then
Not at all.
we can't help it, yes. You have a right to criticize, fairly criticize, but we can't help it sitting here.
It was not the intent.
Yes.
Item of the
Mr. Prabhakar, finally, flood victims today.
Pursuant to my Lord's order on 17th of August, my lord,
Ah,
I have filed an affidavit, my lord, bringing to my Lord's notice the statement which I had made before my Lord's, my lord, I have filed it in form of affidavit to bring it to my Lord's notice, my lord, the action taken by the state. But in paying the
chart is there, madam. Ah,
earlier, I had to inform the board that 20.
Rahul. Lockler, Rahul Reddy. Hey, madam, Rahul Reddy, Lockler. Call him. Hey, no, not here. Lockler. You are looking in the list. Mr. Yes,
But
Prasad.
23 families were paid the ex gratia. Subsequently, not 24 more families have been paid. Ex gratia amount of 4 lakhs.
1 minute. So, Mr.
23rd of August, I
Mr. Prasad, what had happened? 1st August, we had issued certain directions.
Yes.
11th August and 17th of August.
17th of August, my lords were pleased to record my statement. I have requested my lord that I will place it in a place.
All right. Don't call.
I will place it by way of an affidavit.
Not needed. Yes.
I have placed it by way of an affidavit bringing to my lord's notice 24 of.
No, we will ask you. One by one, you please answer. It will be very easy.
My lords.
Because what we have done is we have compiled the directions and your this thing and petitioner submission, right? That's what. So 1 minute. Mr. It is not an adversarial litigation, right? That's why we are asking. They are willing to comply, and we will ensure that they comply.
There have been complied many directions of this.
1 minute. So therefore, we have to pass an order. We have to handle the way this thing. No, who will write? You can this thing. So, first direction on 1st of August, Mr. Prasad, was number of deaths in Jaishankar, Bhupalpalli district.
Yes.
So, how many deaths?
There were 4 deaths, my lord. 4 deaths.
Five.
But 4 they could identify, my lord. 1 was missing. Subsequently, what has happened, my lord? Then the
1 minute. So, 1 is still missing.
Present affidavit, if your lordship sees, present affidavit filed on 20.
No, you tell us. We will not see anything.
I will do this.
You are here, Mr.
One is missing, my lord.
Very few cases we can take the liberty of not referring to record. And when senior advocates appear, we want that to happen, that we should not be, we rely on you. It's not again and again we are telling not an adversarial sort of litigation.
Yes, that's the reason.
So what? Bhupalpalli, this district, 5 deaths took place, 4 identified, 1 is still yet to be identified.
Yet to be identified is.
Arey, Mr. Who is this person standing there?
Mahalakshmi. In the present affidavit, I have said so. Lady by Srimati Gaddam Mahalakshmi of Jaishankar, Bhupalpalli is missing due to the heavy flood. The search operation made with all such.
She is what her name is?
Gaddam Mahalakshmi.
Missing.
Yes.
All.
With regards to the
you will find out.
Yes.
You will carry on the efforts to find out.
With regards to one job.
So, total this thing, how many flood victims are there? You told us 41, correct?
47 for 2 weeks.
No, sorry, not flood victims. Total number of deaths, you told us 41.
Yes.
Correct? Mr.
Yes, 47. 47.
Actually, I claimed 51, my lord. They are showing that 49. Out of that,
I'll explain.
1 minute.
I'll explain. 47. 23, I had informed my lords that 23.
What is your figure? 47.
47
have lost their lives.
Yes.
Then out of, you told us 23 identified benefit given.
24 also have been given. 24 also families have also been
all given.
Yes, 47 have given. One more person, my lord.
All persons given the benefit.
Yes.
Correct.
This is the
position latest.
Yes.
Acha, then we had asked you how many cattle's 813 according to you.
Pardon me.
813 cattle's lost their life on account of floods. That's what you had told us,
Yes.
Mr. Prabhakar.
Mr. Prabhakar.
813.
Yes. Regard to
No, no, you are a stand, Mister. We have gone through it. Your stand is 813. And you will find it out, Mr. Prasad.
I'll find.
So then,
I've also informed the court,
yes.
one person who died, in addition to that, was paid Raitu Bima. Raitu Bima is insurance which was created by the state in favor of the persons who die during the floods.
So all persons insurance given? No.
Only one person was given, that is additional amount of 1 lakh given to a person. Addition to the benefit which is already given, ex gratia of 4 lakhs. Other aspect is with regard to the medical facilities which were made available to the persons who are affected, families affected, duly medicines have been also given to them. Medical facilities have also been given. But now, all the health relief camps,
1 minute. Flood victims, you have given medical relief.
Necessary food, stay and medical support.
Medical relief, food,
stay. But in fresh water.
So how long they will continue to be?
I am informed through this authority, respondent number 5. There are no relief camps now being continued. No relief camps being continued.
No relief camps.
But what I would request.
So what you are trying to tell us that relief to all flood victims where when they needed,
yes,
it has been extended. They were made to stay in flood relief camps, and now nobody is there in flood relief camps.
192
they have returned to their homes.
Yes, 192 relief camps. 20,387 people affected by floods. 192 relief camps. 20,387 people were affected by the floods.
And they were staying in flood relief camps. All of them have gone back to their villages.
Back to their home.
Okay. Then, Acha, you have set up weather stations.
The weather station, I've also given this.
Weather stations.
Yes.
Telangana State Development Planning Society to monitor weather data and hourly information to state data and to promptly take all precautionary steps.
Yes, bro. This is also done.
Done.
Yes. But
it is set up already.
It's set up. But if your lordships kindly see, if your lordship go to C, D and E, C, D and E, the same page, the Chief Secretary of the Head of State has conducted regular teleconferences during the period and video conferences with the district collectors, alerting them regarding the rains forecast and briefing them regarding the measures to be taken. Subsequent day to state has provided 10 NDRF teams deployed to helicopters in critical locations for the purpose of rescue and relocation. Thereafter, along with the IAF, Central Forces, NDRF, the local police and the state fire and emergency departments are deployed in vulnerable locations for rescue and relief. Holidays were also declared by the school to safeguard the. We have set up 192 camps for 20,387 victims. But I've also said that Gaddam Mahalakshmi is missing, and the other person who was referred to by my friend is already been paid.
Yes, we have taken note of the measures. Now, Mr. Prabhakar, what do you say?
Yes, my lord. Maximum they have been complied, my lord. Earlier,
what else is required to be done? You tell us.
Last occasion, this honorable court directed me to what else to be taken place.
That's what we are asking. What else should they should?
Katakarkar stated in my reply, my lord, at page 7.
Forget no page 7. You tell us what do you want.
Yes, my lord. They need to prepare the plans, my lord, according to the Disaster Management Act. If they have been prepared,
what is section 39 of this thing, Disaster Management Act? Mr. Prasad, section 39.
Section 39.
Disaster Management Act.
Yes, section 30. Your lordship may kindly see.
My first of the affidavit, I had requested that the state would be taking all these measures, requesting time till 2024 March. But I had requested my first of the affidavits filed before my lords, appearing saying that everything will be put in place by March 2024.
To prevent the disaster to manage the disaster and to provide the relief.
They have to do it.
Enacted the act, my lord.
We have agreed this.
Yes.
We have agreed to your submission
Yes,
that they need
and
to
the
take measure.
same were upheld by an apex court in Swaraj Abhiyan case.
They are not challenging
Yes, yes.
section 39. They are saying we will comply.
Yes.
It's time to be given that we will decide. I think, Mr. Not till March 24, that means April 24, you will tell us. You see, you take action and submit a compliance report, say by December.
Fine.
Yes.
Fine. Deeply open.
And yes, what else, Mr.?
I have stated 8 suggestions before this honorable court for kind consideration of this honorable court to direct the government to protect the right to life of public at large and property of the public at large. It is 7 I have.
So, Mr. Prabhakar, what now the floods are not there in the state, right?
No, Lord.
1 minute, listen. Now, on a long time, our object is on a long time as a long term measure. We have to ensure implementation of measures under 39.
Yes.
So what we will do is grant them some breathing time of 2.5 months and fix a date in the month of December before vacation and find out from them what section 39 measures have been taken.
Yes.
Correct?
Yes.
Mark the presence.
One more, my humble submission, finally, Millard. The project which is Kaleshwaram constructed under Godavari, Millard, 3 dams are there, Millard. Categorically stated in my reply at page 8, Millard, under 9 also, Millard. Those 3 dams, Millard, they are filling up the water. Once the flood would come, immediately they are releasing the water.
Which dam?
Kaleshwaram, Millard, at page 9, item number 5. Yes. In marriage,
Yes, passed on the suggestions which is making to the state to take appropriate measures.
What is the measure he wants to take?
I have put it across to the state. This is being too technical for me. I have put it across to the state.
Right. Measures to be taken, he has put it across.
Yes.
They need time to respond.
Yes.
We'll grant them. Next date we will ask them what all have done. And about 39, about this dam.
Yes.
Right.
And page 8, Millard, Himayat Sagar, Usman Sagar, which is existed here, west side of the Hyderabad city, and they are not being properly implemented. GOMS number 111 of 1996, which was approved by an apex court, so that Hyderabad is being submerged in many areas, Millard. At page 8, I have categorically stated in item number 3.
Completely a different issue, Millard, which is pending before this. Completely a different.
Mr. One by Mr. Prabhakar, earlier also we had told you we should take the issues which are interconnected. This petition will not be disposed of in December. We will take it up. First is commonality of issues. What relief is 39 and this dam, because it may cause floods again.
Yes.
So we will put them, give them some time of say 10 weeks and ask them to come up with this.
Deeply obliged.
I'm obliged.
Yes. Mark the presence, Mr. Prabhakar. Mr. Prasad. This quote, 1 minute. What is the order? 70. No, first one is in this petition, comma. One is Mark, the state had witnessed continuous heavy rainfall in and around Godavari river, causing floods in low-lying areas, which also resulted in breach of irrigation tanks, severe damages to agricultural crops and roads, and loss of how many lives? Loss of 37 lives.
May I start?
47 lives in the month of between. The rain was between when? Between
19th and
19th July to August 15th.
19 July to,
August 15th.
no, that was second, no.
19th and 20th, 19th and 20th of.
No, my lord, 19th July to August 5th, my lord, in my.
19 July till 27 July 2023.
Yes.
And thereafter in the month of August as well.
Yes.
August as paragraph. This court, a bench of, this court had issued several directions to the state on 1/8/2023, 11/8/2023 and 17/8/2023. Full stop. In pursuance of the aforesaid interim orders, the compliance report has been filed on behalf of the state government. Full stop. The petitioners have also submitted their suggestions which may be implemented by the state government to ensure the safety of public in general in case any flood situation is caused in case any flood situation reoccurs due to heavy rains. So stop. Paragraph. We have heard learned counsel for the parties and have perused the record. Full stop. The from perusal of the perusal of various compliance report, it is it can be gathered that 192 flood relief camps were set up by the state government, in which 20,387 flood victims were granted the relief, granted the medical relief, and were provided food and fresh water. Full stop. The full stop. All the flood victims have now returned to their villages, and no flood relief camps note of, and he doesn't need every time this force direction.
Hopeless, deeply hopeless.
Mr. Other dam also, you find out what can be done.
Yes. In fact, I have forwarded made by request by the petitioner to the state. I'll come back with the report on December 18th.
See, on his own he is submitting. No step. Give one step. What a coincidence, right? You hope this has step. This he submitted section 39, Mr. Prabhakar, and then say Mr. Prabhakar fairly submitted that most of the directions issued by this court have been complied with by the respondents. However, he submits that section 39.
Yes.
Right. You put the pins. Yes.
Deeply hopeless.
That's how public interest litigation should be, right?
Yes.
A constructive sort of an approach.
I ever grateful to your lordships. I ever grateful to your lordships.
No, this thing. We are doing our duty. But this is what it is, how public interest litigation should be argued, Mr. Prabhakar. That's what we are saying.
Yes.
We appreciate your suggestion also.
I'm deeply oppressed.
The otherwise adversarial sort of things.
Yes.
Every day we come across the encroachment on government land, people start arguing like as if it belongs to them. Yes. Okay. Yes, Mr. Advocate General.
My lord, sir. 19, item 19.
My
lord, the cause of the death is, my lord.
19 and 20, in 20 you have to file counter. We shall take it up both the cases together.
Yes, my lord. Yes.
20 they should file counter, right? Already in 19 they have produced the reports, etc. But 20 is a petition by to constitute SIT and take compensation of 50 lakhs.
So
you have please file a counter.
Yes, my lord.
Item number 20, Learned Advocate General, praise fund is granted 4 weeks time to enable him to file counter. Petition is admitted for hearing, right? List along with 19.
Yes.
Yes.
May I present? The issue involved is about the legal issue, my lord. Synopsis, my lord.
Yes, we are ready. So, Mr. Now, no, correct. But we are asking you, now it says stand, right? That there is an arbitration clause. Remedy of a civil suit would be very tedious, right? You know how much time it will take, and first appeal, and then whatever happens, we don't know. So I'm just, before deciding this, we are putting it to you. So don't you think without contesting the case on merits, arbitration in the change scenario would be a better option for you? We will, if we ask to, if you want to really contest, we will enter into and decide. But don't you think that it's a better option now, and the change in stand has been necessitated on account of change in law?
If the intention of the advertisement in the party is to control the litigation.
Yes.
The outcome of it.
Yes.
We have taken up in 2016. In 2016, whether the advertised tribunal was not.
No, we can record a cooperate his undertaking that he will cooperate and will not seek any unnecessary adjournment in the proceeding before arbitrator. Yes. But provided this is by way of a suggestion, then if you want to write it out, then we will have to decide. I think without contesting, it's a better option. That we record his undertaking also, that he will not seek any unnecessary adjournment, will cooperate with the early decision of the proceeding. Arbitral tribunal should be constituted. He will give consent for this thing.
For such a conceding, I have to take instructions from my.
No, but so would you like to seek instruction or contest?
I'll take instruction, I mean, if your lordship kindly considers.
Where,
Because as on today, my lord, we are contesting it.
Ah.
Since your lordship has appealed.
just think about it. It may like,
I paid, my lord, I mean, court fees, I paid this suits in the 2020, my lord, nearly 6 lakh rupees court fees are just paid.
but it will be refunded, no? Now, you will withdraw, then it will be refunded now.
And one more thing,
The only thing is court doesn't give interest, that's all.
Melody, your lordship suggestion is Melody, this variant because within 1 year, even as per the act, also within 1 year, the act will be over. The suit,
No, but you will,
the suit will take years, Melody. In fact, it will be better.
Even now, the suits are pending before the commercial court, where my lord, the time period is fixed for disposal of the suits also. They are now pending before commercial court.
so you think, if you want to argue, we will go ahead.
Since your lordship made a suggestion, my lord, I mean, we have to consider, I have to seek my instructions of my client. I can't readily say
How much time?
maybe within 2 or 3 days, my lord, I can report back to lordship.
6 is, we already have 102, that can't happen. 8th, we can take it up.
Sir, 8, 11, 8,
11th,
Monday.
Monday.
Next Monday, my lord, yes.
Monday 11th. Mark the presence. In this petition, comma, in this appeal filed under section 37 of the Arbitration and Conciliation Act, comma, petitioner has asserted legality of the order dated 2/6/2023 passed by the Commercial Court, by which petition filed by the appellant under section 8 has been rejected. Paragraph. The parties had entered into a registered paragraph. Facts giving rise to filing of this appeal briefly stated are that the parties had entered into a registered development agreement cum general power of attorney on 23/3/2006 full stop, clause 25 of the aforesaid registered development agreement cum power of attorney provides that the dispute between the parties have to be referred to a panel of 3 arbitrators. Out of the aforesaid 3 arbitrators, one each has to be appointed by one party, and the umpire is required to be appointed by remaining 2 arbitrators. Paragraph. The plaintiff invoked the arbitration, plaintiff stroke respondent invoked the arbitration clause, and a dispute was referred to a panel of 3 arbitrators. The full stop, in view of the then prevalent position, legal position as enunciated in so and so versus so and so 2005 within bracket 6 ALD, right? ALD
2015, madam.
15 6 ALD 584 comma 584 comma that dispute regarding cancellation of registered documents are not maintainable, comma, the plaintiff stroke respondent withdrew the arbitration proceeding and filed there full stop. Thereafter, the petitioner filed a suit for cancellation of this thing, DAGPA, whatever, DAGPA, full stop. The defendant number 1 thereupon filed an objection under section 11 within bracket under section 8 on the ground that the agreement executed between the parties, this whatever agreement executed between the parties dated 23/3/2016 contains an arbitration clause in view of later decision of Supreme Court in dash versus dash 2021 volume 4 SCC 786. Paragraph. Paragraph. The commercial court by an order dated so and so 2/6/2013
Interim order needs to be extended.
Interim order shall continue. Then say list on 12th September 21, 22, 23.
Black.
So previous, my lord, this matter, I will also filed, my lord, and appellate, and grant 2 weeks time, my lord.
What? Vacate stay petition.
Yes, my lord. I'll make a step.
That's why senior counsel is smiling. That's
ma'am.
so conveniently you are saying.
Earlier in this matter, my lord, additional sergeant appeared, my lord. Now the inform department.
You have filed vacate petition.
I filed.
Appellate.
You have filed.
I filed. Okay.
Then his petition, right?
Yes, sorry.
What do you say, senior counsel? 2 weeks for what we don't know. What happened? This thing proceedings are before under the act have been concluded. This thing final stage.
No, not concluded, my lord. They wanted to appoint a surveyor, my lord, to survey the property.
No, interim order granted by this court says that you continue with the proceeding, but final order shall not be passed. That's why we are just trying to ascertain the reasonableness of the prayer for adjournment with reference to each stage of the
They
proceeding.
wanted to conduct the survey, my lord, till that it has not happened, my lord.
Right, so we can grant them time.
2 weeks.
But argue on the next date of hearing. Senior counsel has today didn't say anything, but next day he will oppose, right? Mark the presence.
Deeply.
This court by an interim order dated, a bench of this court by an interim order dated 14/7/2022 and directed that the proceeding under the Public Premises Eviction of Unauthorized Occupants Act 1971 may continue, but final order shall not be passed. Full stop. The respondents have filed an application seeking vacation of the interim order. However, learned counsel for the petitioner prays for adjournment to enable him to prepare the case and argue the same. List on 18th September 23 for consideration of IA so and so seeking vacation.
Deeply obliged.
He wants to complete through interim orders of this court. Now comes the permission to attend classes.
The classes start. That was granted, my lords. Classes are big.
So what IA you have now? It has
IA 2 has also been allowed. Yes,
So
it has
what
been
is
allowed.
1 of 23? No orders necessary to be passed on 1 of 23.
1 of 23.
What is 1 of 23?
No orders are necessary. To appear for the examination, that has also done.
All right.
He's also attending.
He's the petitioner, right?
Yes.
Advise him to attend classes.
Yes.
And not to spend time here in the courts.
The classes haven't begun, man. Like I asked him even today.
Advise him to be in the library, read all the classic case laws of. I think you will inspire him to do something better than not attending classes and this thing.
In fact, I've been literally parenting him on that.
Yeah.
Telling him you are better go back to college. Yes, starting next week.
Mark the presence. Learned Senior Counsel submits that IA 1 of 23 has already been allowed. Therefore, no orders are required to be passed on IA 1 of 23.
Right.
What amendment?
To represent. Lords have filed amendment petition.
Yes, what do you think, Mr.
My lord,
Can we allow amendment?
my lord, can be closed, my lord, because my lord, the repetition can be closed, my lord. The section 243, my lord, the last occasion, my lord, please wait to get instructions. The 243, repeal of certain enactments of savings. Now, my lord, this repealing is not yet notified. But you can avail the remedy under 243, my lord, and after leaving
Why he can avail of the remedy?
Personal insolvency.
Madam, IA, my notes, please give. I can't see. Yes. say, the grievance is that section 94 is not notified of the IBC.
Yes, yes.
So he cannot get a declaration that I am insolvent. This is number one.
Yes.
Secondly, he says that he had filed a petition under Provincial Insolvency Act. It was rejected by an order dated 8/12/21.
Yes.
So he is remediless and therefore under Article 226 an interim order.
Therefore, the repeal, section, the very itself, it is not notified. Therefore, we can avail the
No. But the problem is, Mr. Praveen Kumar,
my lord.
is he had filed the petition under provincial insolvency.
Yes.
It has been rejected by an order dated 8/12/21. Where is it, Mr. 8?
Page 41, my lords.
41.
Neat copy is at page 41A.
8/12/21, right?
Yes, my lords.
Page
41A.
41A.
Yes, my lords. 41 is the title.
Returned for. Who has returned?
The small causes court section, my lords, on the ground that how IP is maintainable under.
Page 26, main case.
We will, Mr. Order, we'll set aside this order.
One submission, my lords. I have prepared the notes. One submission I will make.
No. Mr. We are granting relief and you are making
Yes,
some.
yes, my lords.
This order we will set aside and the ask the this thing small causes court to try your petition
Yes,
on
sir.
merits.
Yes.
There are two learned single judge judgment of this honorable court. If your lordship so says, my lords, I will pass on that. Because that has to go.
What thing? What orders, single judge?
I may be permitted to pass on, my lords. I have prepared small notes also if your lordship so previous notes.
Oh, nice. No, but what, why it has been written, why, what has been held?
They say that under section 8, because section 8 of the Provisional Insolvency Act bars petition against banks, companies and corporations. That is the view of some other high courts also, my lord. But Kerala High Court, my lords, has said no, section 8 doesn't bar it because, my lordship, if your lordship sees section 8, there is ambiguity in the main provision.
Mr. He doesn't want closure of the petition. He wants to continue perpetuity because interim order is granted. He wants it should come up after 25 years. By that time, petitioner would have left the world. He will be designated senior counsel. Lighter when we are saying, Mr. Don't take everything seriously, right?
I cannot take.
Cannot take. No, very good. Good not to take things serious. So, what is the reasoning of the decision of single benches you are saying?
My lord, they,
Of our court is the reasoning.
Yes,
Which
they-
page?
page number, my lords, of this honorable court.
You have High Court of Allahabad, you have.
Yes,
right,
that
I think
different high courts. Page number 10 is our high court. Page number 13 is our high court.
10. So, it should be annexed in the compilation first, right? Allahabad judgment, nothing single bench.
Yes, my lords.
What is it?
Page number 10, my lords.
1 minute, one.
So,
You have filed against whom?
my lords,
You have filed the petition against whom?
against the banks.
Then section 8 prohibits filing of such a petition against bank.
It is what the learned single judge say, my lord.
No, what does section 8 say?
says against corporations, association or company registered under any enactment.
So it's not either of these. Bank is a separate entity.
One submission, my lords. Company registered under any law, banks, all banks under Banking Regulation Act of 1949 come under the company registered under any law.
So you are saying that no remedy.
Yes, that is what page number 13, my lords, another single judge of this honorable court has categorically in point of the banks have said. Page number 13, para level.
Case of bank.
Case of banking, page number
So
30.
then this should have been the first decision in your compilation.
I'm sorry, my lords.
This applies directly to your case, right?
Yes, my lords.
It should be first in compilation. Page 11. Yes, Mr. It requires consideration. Madam. We'll admit it.
Yes, sir.
You are already surviving on an interim order, right? Be happy.
Yes.
It's for admission.
Yes, my lords.
Heard on the question of admission. Good effort put in.
Obliged, my lords.
So that's how you should do it. Where is that this thing?
I have given notes.
Note. We don't have any note. Synopsis.
Yes, my lords.
Good. Keep it up, Miss Young man. Yes. The petitioner heard on the question of admission. The petitioner had availed of loan from respondents 4 to 17 to the tune of rupees 3.25 crores. Full stop. It is the case of the petitioner that on account of circumstances beyond his control, amendment allowed.
Yes, ma'am.
Heard on beginning right. Heard on IA 2 of 23, taking into account the nature of proposed amendment, same is allowed. Let amended petition be filed within
We have filed, my lords. After filing only number comes.
All right. Allowed.
Oblige, my lords.
Petition is admitted for hearing, counter if any be filed within 6 weeks. Next.
Your lordship, item 28 and 29, your lordship are questioning the GOM.
Admitted for hearing. 6 weeks time is
Batch is pending.
6 weeks.
Batch is pending, your lordship.
6 weeks time is for granted to file counter list along with WP number.
350,507.
WP
WP 33507 and 2022. This batch is there.
Madam, right? Yes. Yes. Yes.
What's your item
32, madam, 54. 32, 54. Yes. They counter is not filed.
Counter is not filed by the state, madam. State has to file the counter because rule is.
Petition is admitted for hearing.
In this case,
Let counter if any.
in this case, in one of the case, I filed the counter. In all cases, is similarly situated, where
Memo has to be filed or copy has to be given. Which case you have filed counter? Mr. Item number 32.
54, madam.
54.
All cases.
Which case?
Copy, sir.
1 minute. Which case you have filed counter?
In Aravindo Pharma, I filed, madam.
No, we don't know Arvindo Pharma number, serial number.
Item 34, 34, my lords.
34.
Yes.
Madam, in WP 22739 of 22, I filed the counter.
My madam.
No, this is not WP 27. Which case?
32, madam. Item 32.
Municipality, others.
22739.
Yes, madam. This is related to Aravindo Pharma.
Municipality seems to have filed counter, madam. This matter, not the government.
He is government, right?
Administration I filed.
Very good.
Because municipal administration.
Same counter they can pass on to all the other case also.
Item 30 to 54, madam.
In fact, my lords, we have included in documents for us. Those documents are not shown on only the copy of the copies. Refer to certain circulars, my lords.
Speak into the mic so that your friend can hear. He is not heard.
Certain circulars which have been referred in the counter, my lords, those were not served upon me. Only the counter
Item
copies.
30 to 54. You are government advocate. What? Government pleader.
I will file counter. I will GP for municipal administration.
GP for municipal administration submits that he has filed counter in WP number 22739 bar 2022. Learned on the learned counsel for the petitioner submits that learned counsel for petitioner in WP number 22739 bar 2022 submits that he has not received the copy of annexures, copy of documents annexed with the counter. Paragraph in view of aforesaid submission, learned GP undertakes to supply a copy to Mr. Counsel for petitioner in WP number aforesaid rate petition, right? the land held by the petitioner say, 1 minute. His submission, learned senior counsel for the petitioner, read just now. It is further submitted, one line. It is further submitted that claim of the petitioners except the petitioners to whom the compensation has already been paid be examined within a fixed time limit by the competent authority. They will not go, Mr. They, on the other hand, then what he submitted shall be examined. Examined. Such of the petitioners grievance, madam, read what is his submission. No, you don't, claims of the petitioners, claim of such petitioners to whom the benefit of compensation, delete everything, to whom the benefit of compensation has not been extended, shall be examined by the RDO Siddipet within a period of 2 months from today, and the amount due to them shall be paid to them. Paragraph. We have considered the rival submissions made on both sides. Para 8 of the will find out. If we don't find out, then you are just getting, give it. Other, we have 3420, we have other memo you do. Read as in the quote. Paragraph. In view of the, no, not this memos. Therefore, it is, therefore, in view of the consensus, right, in view of consensus arrived at between the parties, and in view of the fact that the petitioners have confined their grievance to paras 8 of the memo, dated 4/7/2023, filed in all the 3 writ petitions, it is directed that the Revenue Development Officer Siddipet shall consider the claims of the petitioners, within a period of 2 months from today by a speaking order. Needless to state that the
Okay, much good.
under Article 226 will not be exercised in favor of a person who sleeps over his rights. In case you wanted to participate in the counseling for the state of Telangana, you had to adhere to the time schedule prescribed by them. The time schedule for every candidate alike was 3rd August 23 to 12 August 23. Yes.
Mortgage. It doesn't need any instrument per se, not even any registered instrument, my lord. These are few of the visions, my lord, because that's why, my lord, the doctrine of ageisdom generis won't apply. But for doctrine of ageisdom generis to apply, it should contain of the same genus, then the specific words would fall under that. My lord, but these words, the use of word contract in the statute, the use of word lease, sale, exchange, few among them, my lords, do not even require registration. Therefore, my respectful submission is that it comes under the ambit of word transfer, which has a wider ramification, my lords. It doesn't, what's confined to this, and doctrine of ageisdom generis wouldn't apply, my lords, is my respectful submission. Because, my lord, the word any is used.
Yes, yes. Anything else?
That's it. I have given the brief synopsis.
Yes. Yes.
Obliged.
You have argued it well, Mr. Keep it up.
Obliged.
Yes.
Connection between the
core issue is this is slipper. No. This he submitted section 39, Mr. Prabhakar, and then say Mr. Prabhakar fairly submitted that most of the directions issued by this court have been complied with by the respondents. However, he submits that section 39.
Yes.
Right. You put the pins. Yes.
Keep your place.
That's how public interest litigation should be, right?
Yes.
A constructive sort of an
Yes.
approach.
I ever grateful to your lordships. I ever grateful to your lordships.
No, this thing. We are doing our duty. But this is what it is how public interest litigation should be argued, Mr. Prabhakar. That's what we are saying.
Yes.
We appreciate your suggestion also.
I'm deeply obliged.
The otherwise adversarial sort of things.
Yes.
Every day we come across the encroachment on government land, people start arguing like as if it belongs to them. Yes. Okay. Yes, Mr. Advocate General.
My lord, sir. 19, item 19.
My
lord, the cause of the death is, my lord.
19 and 20, in 20 you have to file counter. We shall take it up both the cases together.
Yes, my lord. Yes.
20 they should file counter, right? Already in 19 they have produced the reports, etc. But 20 is a petition by to constitute SIT and take compensation of 50 lakhs.
So file
you have please file a counter.
Yes, my lord.
Item number 20, Learned Advocate General, praise fund is granted 4 weeks time to enable him to file counter. Petition is admitted for hearing, right? List along with 19.
Yes.
Yes.
May I please? The issue involved is about the legal issue, my lord. Synopsis, my lord.
Yes, we are ready. So, Mr. Now, no, correct. But we are asking you, now it says stand, right? That there is an arbitration clause. Remedy of a civil suit would be very tedious, right? You know how much time it will take and first appeal and then whatever happens, we don't know. So I'm just, before deciding this, we are putting it to you. So don't you think without contesting the case on merits, arbitration in the change scenario would be a better option for you? We will, if we ask to, if you want to really contest, we will enter into and decide. But don't you think that it's a better option now, and the change in stand has been necessitated on account of change in law?
If the intention of the advertisement in the party is to construct the
Yes.
the outcome of it.
Yes.
That we have taken up in 2016.
Ah.
And 2016, whether the arbitration tribunal was not.
No, we can record a cooperate, his undertaking that he will cooperate and will not seek any unnecessary adjournment in the proceeding before arbitrator.
Yes.
But provided, and this is by way of a suggestion, then if you want to write it out, then we will have to decide. I think without contesting, it's a better option. That we record his undertaking also that he will not seek any unnecessary adjournment, will cooperate with the early decision of the proceeding. Arbitral tribunal should be constituted. He will give consent for this thing.
For such a conceding, whether I have to take instructions from my.
No, but so would you like to seek instruction or contest?
I'll take instruction, whether, I mean, if your lordship kindly considers.
Where?
Because it is on today, whether we are contesting it. Since your lordship has,
Just think about it. It may like.
I paid, whether, I mean, court fees, I paid this suits in the 2020, whether nearly 6 lakh rupees court fees are just paid.
But it will be refunded, no? No. You will withdraw, then it will be refunded now.
One more thing.
The only thing is court doesn't give interest, that's all.
Melody, your lordship suggestion is Melody, this variant because within 1 year, even as per the act, also within 1 year, the act will be over.
No, but you will.
The suit will take years, Melody. In fact, it will be better.
Even now, the suits are pending before the commercial court, where the time period is fixed for the disposal of the suits also. They are now pending before commercial court.
So you think, if you want to argue, we will go ahead.
Since your lordship made a suggestion, I mean, we have to consider, I have to seek my instructions of my client. I can't readily say.
How much time?
Within 2 or 3 days, I can report back to lordship.
6 is, we already have 102, that can't happen. 8th, we can take it up.
8, 11, 8,
11?
Monday.
Monday?
Next Monday.
Monday 11. Mark the presence. In this petition, comma, in this appeal filed under section 37 of the Arbitration and Conciliation Act, comma, petitioner has assailed legality of the order dated 2/6/2023 passed by the Commercial Court, by which petition filed by the appellant under section 8 has been rejected. Paragraph. The parties had entered into a registered paragraph. Facts giving rise to filing of this appeal briefly stated are that the parties had entered into a registered development agreement cum general power of attorney on 23/3/2006 full stop clause 25 of the aforesaid registered development agreement cum power of attorney provides that the dispute between the parties have to be referred to a panel of 3 arbitrators. Out of the aforesaid 3 arbitrators, 1 each has to be appointed by one party, and the umpire is required to be appointed by remaining 2 arbitrators. Paragraph. The plaintiff invoked the arbitration, plaintiff stroke respondent invoked the arbitration clause, and a dispute was referred to a panel of 3 arbitrators. The full stop in view of the then prevalent position, legal position as enunciated in so and so versus so and so 2005 within bracket 6 ALD, right? ALD
2015, madam.
15 6 ALD 584 comma 584 comma that dispute regarding cancellation of registered documents are not maintainable, comma, the plaintiff stroke respondent withdrew the arbitration proceeding and filed a full stop. Thereafter, the petitioner filed a suit for cancellation of this thing, DAGPA, whatever, DAGPA, full stop. The defendant number 1 thereupon filed an objection under section 11 within bracket under section 8 on the ground that the agreement executed between the parties, this whatever agreement executed between the parties dated 23/3/2016 contains an arbitration clause in view of later decision of Supreme Court in dash versus dash 2021 volume 4 SCC 786. Paragraph. Paragraph. The commercial court by an order dated so and so 26/2013
Entry model needs to be extended.
entry order shall continue. Then say list on 12 September 21, 22, 23.
Black.
So previous my lord, this matter, I will also file my lord and appellate and grant 2 weeks time, my lord.
What? Vacate stay petition.
Yes, my lord. My vacant stay.
That's why senior counsel is smiling. That's so conveniently you are saying.
Earlier in this matter, my lord, additional sentinel appeared, my lord. Now the informed department.
You have filed vacate petition.
I filed.
You have filed.
I filed. Okay.
Then his petition, right?
Yes, sorry.
What do you say, senior counsel? 2 weeks for what we don't know. What happened? This thing proceedings are before under the act have been concluded. This thing final stage.
No, not concluded, my lord. They wanted to appoint a surveyor, my lord, to survey the property.
No, interim order granted by this court says that you continue with the proceeding, but final order shall not be passed. That's why we are just trying to ascertain the reasonableness of the prayer for adjournment with reference to each stage of the proceeding.
They wanted to conduct the survey, my lord, till that it has not happened, my lord.
Right, so we can grant them time.
2 weeks.
But argue on the next date of hearing. Senior counsel has today didn't say anything, but next day he will oppose, right? Mark the presence. This court by an interim order dated, a bench of this court by an interim order dated 14/7/2022 and directed that the proceeding under the Public Premises Eviction of Unauthorized Occupants Act 1971 may continue, but final order shall not be passed. Full stop. The respondents have filed an application seeking vacation of the interim order. However, learned counsel for the petitioner prays for adjournment to enable him to prepare the case and argue the same. List on 18 September 23 for consideration of IA so and so seeking vacation.
Deep low list.
So he wants to complete through interim orders of this court. Now comes the permission to attend classes.
The classes start. That was granted, my lords. Classes are big.
So what IA you have now? It has
IA 2 has also been allowed. Yes,
so
it has
what
been
is
allowed.
1 of 23? No orders necessary to be passed on 1 of 23.
1 of 23.
What is 1 of 23?
No orders are necessary. To appear for the examination, that is also done.
All right.
He is also attending.
He is the petitioner, right?
Yes.
Advise him to attend classes.
Yes.
And not to spend time here in the courts.
The classes haven't begun, man. Like I asked him even today.
All, I mean, advise him to be in the library, read all the classic case laws of. I think you will inspire him to do something better than not attending classes and this thing.
Definitely. In fact, I've been literally parenting him on that.
Yeah.
Telling him you have better go back to college. Yes, starting next week.
Mark the presence. Learned Senior Council submits that IA1 of 23 has already been allowed. Therefore, no orders are required to be passed on IA1 of 23.
Right.
What amendment?
I beg to represent. Alerts have filed amendment petition.
Yes, what do you think, Mr.
Milord,
Can we allow amendment?
Milord, can be closed, Milord, because Milord, the repetition can be closed, Milord. The section 243, Milord, the last occasion, Milord, please wait to get instructions. Milord, 243, repeal of certain enactments of savings. Now, Milord, this repealing will not get notified. Milord, you can avail the remedy under 243, Milord, and after
why he can avail of the remedy?
Personal insolvency.
Madam, my notes, please give. I can't see. Yes. Say, the grievance is that section 94 is not notified the IBC.
Yes.
So he cannot get a declaration that I am insolvent. This is number one.
Yes.
Secondly, he says that he had filed a petition under Provincial Insolvency Act. It was rejected by an order dated 8/12/21.
Yes.
So he is remediless and therefore under Article 226 an interim order.
Therefore, Milord, the repeal, Milord, section, the very itself, Milord, it is not notified. Therefore, you can avail in our old act.
No. But the problem is, Mr. Praveen Kumar, is he had filed the petition under provincial insolvency.
Yes.
It has been rejected by an order dated 8/12/21. Where is it, Mr. 8?
Page 41, my lords.
41.
Need copies at page 41A.
8/12/21, right?
Yes, my lords.
Page
41A.
41A.
Yes, my lords. 41 is the type.
Returned for. Who has returned?
The small causes court section, my lords, on the ground that how IP is maintainable under.
Page 26, main case.
We will, Mr. Order, we'll set aside this order.
One submission, my lords. I have prepared the notes. One submission I will make.
No. Mr. We are granting relief and you are making some.
Yes, my lords.
This order we will set aside and ask the this thing small causes court to try your petition on merits.
Yes.
There are two learned single judge judgment of this honorable court. If your lordship so says, my lords, I will pass on that because that has to go.
Watching. What orders, single judge?
I may be permitted to pass on, my lords. I have prepared small notes also with your lordship, so previous notes.
Oh, nice. No, but what? Why it has been written? Why? What has been held?
They say that under section 8, because section 8 of the Provisional Insolvency Act bars petition against banks, companies and corporations. That is the view of some other high courts also, my lord. But Kerala High Court, my lords, has said no, section 8 doesn't bar it because, my lordship, if your lordship sees section 8, there is ambiguity in the main provision.
Mr. He doesn't want closure of the petition. He wants to continue perpetuity because interim order is granted. He wants it should come up after 25 years. By that time, petitioner would have left the world. He will be designated senior counsel. Lighter when we are saying, Mr. Don't take everything seriously, right?
I cannot take.
Cannot take. Good not to take things serious. So, what is the reasoning of the decision of single benches you are saying?
My lord, they,
of our court is the reasoning.
Yes,
Which page?
page number, my lords, of this honorable court.
You have High Court of Allahabad, you have.
Yes, that different high courts. Page number 10 is our high court, page number 13 is our high court.
10. So it should be annexed in the compilation first, right? Allahabad judgment, nothing, single bench.
Yes, my lords.
What is it?
Page number 10, my lords.
1 minute, one.
So,
You have filed against whom?
my lords,
You have filed the petition against whom?
against the banks.
Then Section 8 prohibits filing of such a petition against bank.
It is what the learned single judge say, my lord.
No, what does Section 8 say?
Against corporations, association or company registered under any enactment.
So it's not either of these. Bank is a separate entity.
One submission. Company registered under any law, banks, all banks under Banking Regulation Act of 1949 come under the company registered under any law.
So you are saying that no remedy.
Yes, that is what page number 13, my lords, another single judge of this honorable court has categorically in point of the banks have said. Page number 13, para 11.
Case of bank.
Case of banking, page number 13.
Then this should have been the first decision in your compilation.
I'm sorry, my lords.
This applies directly to your case, right?
Yes, my lords.
It should be first in compilation. Page 11. Yes, Mr. It requires consideration. Madam. We'll admit it.
Yes, sir.
You are already surviving on an interim order, right? Be happy.
Yes.
It's for admission.
Yes, my lords.
Heard on the question of admission. Good effort put in.
Oblige, my lords.
So that's how you should do it. Where is that this thing?
I have given notes.
Note. We don't have any note. Synopsis.
Yes, my lords.
Good. Keep it up, Miss Young Man. Yes. The petitioner heard on the question of admission. The petitioner had availed of loan from respondents 4 to 17 to the tune of rupees 3.25 crores. Full stop. It is the case of the petitioner that on account of circumstances beyond his control, Amendment allowed.
Yes, ma'am.
Heard on beginning, right? Heard on IA 2 of 23, taking into account the nature of proposed amendment, same is allowed. Let amended petition be filed within.
We have filed, my lords. After filing only number comes.
All right. Allowed.
Oblige, my lords.
Petition is admitted for hearing, counter if any be filed within 6 weeks. Next.
Your lordship, item 28 and 29, your lordship are questioning the GOM.
Admitted for hearing. 6 weeks time is.
Batch is pending.
6 weeks.
Batch is pending, your lordship.
6 weeks time is for granted to file counter list along with WP number.
350,507.
WP.
WP 33507 and 2022. This batch is there.
Madam, right. Yes. Yes. Yes.
What's your place?
32, madam, 54. 32, 54. Yes. They counter is not filed.
Counter is not filed by the state, madam. State has to file the counter because rule is.
Petition is admitted for hearing.
My lord, in this case,
Let
my lord,
counter if any.
in this case, my lord, in one of the case, my lord, I find the counter. In all cases, is similarly situated, my lord, where
Memo has to be filed or copy has to be given. Which case you have filed counter? Mr. Item number 32.
54, madam.
54.
All cases. My lord, I will
Which
file the
case?
copy, sir.
1 minute. Which case you have filed counter?
In Aravindo Pharma, I filed, my lord.
No, we don't know Arvindo Pharma number, serial number.
Item 34. 34, my lords.
34.
My lord, in WP 22739 of 22, I filed the counter.
This is not WP 27. Which case?
32, my lord, item 32.
Municipality, others.
22739.
Yes, my lord. This is related to Aravindo Pharma.
Municipality seems to have filed counter, madam. This matter, not the government.
He's government, right?
Administration I filed.
Very good.
Because municipal administration.
State counter, they can pass on to all the other case also.
Item 30 to 54, madam.
In fact, my lords, we have included in documents for us. Those documents are not shown on only the copy of the copies. Refer to certain circulars, my lord.
Speak into the mic so that your friend can hear. He is not heard.
My lord, certain circulars which have been referred in the counter, my lord, those were not served upon me. Only the counter
Item
copies, sir.
30 to 54. You are government advocate. What? Government pleader.
I will file counter. I will, GP for municipal administration.
GP for municipal administration submits that he has filed counter in WP number 22739 bar 2022. Learned on the learned counsel for the petitioner submits that learned counsel for petitioner in WP number 22739 bar 2022 submits that he has not received the copy of annexures, copy of documents annexed with the counter. Paragraph in view of aforesaid submission, learned GP undertakes to supply a copy to Mr. Counsel for petitioner in WP number aforesaid rate petition, right?
Your Lordship.